Thank you, Tanner. Welcome, everybody. This is February 21st, 24. Senate Minerals, and we got a few bills to consider this morning. We are a little short-handed, so kind of bear with us, and we'll try to get through this. I believe our first bill for consideration this morning is Senate File 80, Solid Waste Management, Definitions and Amendments. Is there somebody here that'd like to present this to us? If you'd come up and tell us your name and for the record, and we'll turn it over to you.
Mr. Chairman, my name is Alan Edwards. I'm the Deputy Director for the Department of Environmental Quality. We had assumed that the author, the sponsor of the bill would walk through it, but we are here to answer any questions and just provide the department's input on that. And for that, I'll turn it over to Suzanne.
Good morning, Mr. Chairman, members of the committee. My name is Suzanne Eagles. I'm the administrator of the Solid and Hazardous Waste Division at DEQ. As Deputy Director Edwards mentioned, we were anticipating the sponsor of the bill to walk through this, but I can go through and point out the summary of each section before I go into my talking points.
Okay. Thank you, ma'am.
So, Mr. Chairman, this bill is to amend the definitions of solid waste management in our statute, and section 1 is specifically on those definitions where you see those amendments exempting specific types of facilities from solid waste, the definition of solid waste. And then later on page 3, line 9, there's a definition for advanced recycling facilities, as well as on line 20, it just expands what an advanced recycling means and an advanced recycling facility. Section 2 on page 4 directs the Environmental Quality Council to promulgate rules upon recommendation of DEQ. And section 3 there on page 4 also makes sections 2 and 3 effective immediately.
Thank you, Ms. Ingalls. If you want to go ahead and give us all your insight on this and tell us where we're running amok.
Sure, Mr. Chairman. So the department's understanding of this bill is that it amends the definitions of a solid waste and a solid waste management facility and provides definitions of advanced recycling. And 24 other states in the country have adopted similar legislation that would exempt this type of facility from a solid waste permit. And at the agency, we issue solid waste permits to treatment facilities. And the benefit to that permit, we call it a low hazard, low volume permit. The facility is required to meet location standards, provide financial assurance, as well as there's a public comment opportunity for the public to provide their feedback on that permit. So with this bill, it would exempt these facilities where they're doing advanced recycling, where they would not be required to obtain that permit. I mentioned that 24 other states have similar legislation. Utah is another state in our region, Region 8, that has recently adopted that legislation. And as far as the department is aware, we have not been approached by a company interested in this type of permit. And we have not issued any permits to a facility like this.
Thank you. Questions? Anything to add for us, Mr. Edwards or Director? Excuse me.
Thank you, Mr. Chairman. I think in summary, we would say that we don't see any complications in the agency being able to administer this based upon the language that's in the bill currently.
Okay, thank you, Director. Any other questions for Director Edwards or Ms. Ingalls? I guess we'll move forward. Is there anybody else in the room who wants to testify? Jump right in here and for the folks online, tell us your name and
All right. Thank you, Mr. Chairman. I'm Jason Beggar, and today I'm here on behalf of the American Chemistry Council. And as it was mentioned, there's 24 other states that have pushed legislation like this, and, they're the main driver for this nationwide. They're trying to kind of standardize and equalize these statutes across the country, and kind of the big reason why is technology has changed. If you look at any plastic bottle, usually there's a number on the bottom that kind of designates what kind of plastic it is. Some plastics, they can be melted down, reshaped, reformed. A lot of plastics, things like cellophane wrappers on food or pharmaceutical packaging, or there are any number of types of plastics that are just, you can't recycle in that manner, so they're landfilled. So new technologies using gasification and pyrolysis are able to, through heat and pressure, break down those plastics into the basic chemical components that can then be reconstituted into new plastics and new products. And moving forward with that technology, they realized in many states, the regulatory pathway didn't exist to do things like that. So what this bill does is it defines what advanced recycling is, and also says those types of advanced recycling facilities will be treated as a manufacturing facility and would be exempt from a typical solid waste facility. And the reason behind that is an advanced recycling facility is just a pass-through facility. At the back end, you've got either new products going out to market, or you would have, if there are certain, waste products, those would go to a permitted disposal facility. But just because it's not regulated under that solid waste provision doesn't mean that it's not regulated. A facility like that would still be subject to all types of manufacturing permits. The one that certainly comes to mind is an air permit. You'd need that, but depending on the process, if you're using a lot of water, you might need those associated prior permits. On a county level, any array of siting and zoning type, permits that go along with it. So they're still regulated. They're just regulated differently, more akin to a manufacturing facility than a waste disposal. So I hope that answers any questions. And I guess I'd be more than happy to do my best to answer questions if you have some.
thank you, Mr. Burr. Questions for Mr. Burr? None? Seeing none, I guess we'll let you move away there. Is there anybody else in the room that would like to testify here today? Tanner, do we have anybody online? Nobody online. Okay, so I guess we'll close public comment on this. And committee, what's your pleasure?
Move the bill. Second.
Moved by Senator Ellis. Any discussion? Thoughts?
Mr. Chairman, just a little discussion. I've read this bill and looked at it and visited with some of the proponents. I think it looks really good. I was telling Senator Jones, though, if you look at the enactment date, this is the effective date. This always drives me bonkers. It's, the really lengthy effective date to clarify that rulemaking can continue. We just have inconsistencies in how we draft these. So my preference would be just do July 1st, but I'm going to leave it as is. It's fine.
Thank you, Senator Ellis. Are you wanting to make an amendment to it or no? Okay. So I sense we're ready for the question on it. A roll call, please.
Senator Ellis,
Aye.
Senator Jones,
Aye.
Senator Rothfuss,
Excused?
Co-Chairman Dockstader,
Excused?
and Chairman Cooper.
Aye. Tanner, we want to leave this vote open for the gentleman when they get back. Very good. We'll zip right through that one. Let's talk about Senate File 96. Trust and bank assets and bankruptcy clarification. Who do we have in the room that wants to? lead us through this.
Mr. Chairman, I, just,
Don't everybody come all up.
Yeah.
I know.
See everybody jumping up here.
This is a product of some work that we did in the blockchain task force, or the blockchain committee. I can tell you that I got on, Senator Rothfuss chairs that and is very knowledgeable and could probably walk you through this. I would feel ill-equipped to do that. So I am looking in the audience. I know we've got people who are interested and wondering if they feel comfortable presenting the bill to us or not. If not, then we could maybe switch the order a little bit and go back to, and do the regulatory task force, but it depends on.
I think it
Your
might be
preference.
beneficial to lay this back for just a few minutes and see if Senator Rothfuss shows up
I would agree with that.
and move forward to Senate File 131, Regulatory Reduction Task Force. Looks like about the same kind of thing here. Is anybody in, oh, here we go. Come on up if you would, please. Bob, and tell us your name and who you're representing today, and kind of lead us through this, if you would.
Good morning. I'm Bob McLaurin with WHAM. We worked with the Regulatory Reduction Task Force last summer. Don't have any problems with this bill, but would like to talk to you about an amendment, specifically on page 3, line 11, where it says a member representing Wyoming local governments. We would respectfully request that a member of WHAM from the cities be on here, and a member of somebody from the counties. And ideally, we like to be consulted about who we put on, but we often work shoulder to shoulder and hand in hand with the counties, and there's sometimes we have differences of opinions on issues. So I think to complete it, we'd appreciate the opportunity to have one from each organization.
Okay. Thank you, Bob. We'll kind of run through the bill real quick, and then we'll take a look at that amendment.
Mr. Chairman, may I ask a question?
Senator Ellis?
So, I'm sorry, who's on there now? I'm guessing this mirrors it continues the
It
task
was,
force.
the local government rep last summer was Mark Barron from Jackson. And he had been a mayor, former county commissioner. But we believe that each side should be represented on the task force.
Follow-up question?
Senator Ellis?
Thank you, Mr. Chairman. So I think, Mr. Barron would have that unique experience of having worked on the local side and the county commissioner side. So I'm just trying to understand if that person exists, or is he no longer willing to kind of serve, or?
I haven't checked with Mr. Barron on this, but our organization just believes it would be good to have 2 individuals.
Follow up again?
Thank you. Senator Ellis?
Thank you, Mr. Chairman. Mr. McLaurin, have you consulted with the prime sponsor of this bill about your idea?
No, ma'am, I haven't.
Thank you.
Thanks, Bob. Any other questions from the committee? Do we want to run through this real quick, or is everybody comfortable with where we're at on it, or?
More public testimony?
Yeah, I didn't know if we wanted to run through the bill first before we ask for more public testimony, but or do we need to call the EMS? We all right? All right. Is there any other public testimony? Come on forward and.
Regulatory reduction task force.
Yeah. Yes, so we're discussing Senate File 131.
Mr. Chairman, committee, thank you. My apologies, we've got a couple of committee meetings this morning. As you know, today's an important day
Yep.
to visit. Jesse Defoe, representing Freedom Path 307. We're a policy think tank that just encourages economic development, pro-business, and most importantly, why I'm testifying today is regulatory reduction. And so really grateful for the opportunity to visit today. I'm sure that you guys are well aware there are 3 bills right now moving through. session that came directly from this task force, so we know it's a proven concept. And we've seen that working right now to look at that, and we're really grateful for it. We've seen good work, but we also know that there's still a lot of work to do. And we feel like businesses in Wyoming operate best when there's clarity. And so when there's clarity through these regulations and different things that we're looking at, then businesses know what their risk is in taking that. And I think a lot of the things that they're looking at right now had really great intentions when they were set out, and then through rules, may have kind of taken a different turn. And that's where this task force can take a look at that in reference to the amendment that we just heard. I think that you need a clear eye when looking at these things. And so I would encourage you to think about what you've asked this group to do, and if they can objectively look at all those and provide really great resources for how to address the regulation and what that looks like. Just appreciating our process. So, I mean, we are in full support of this task force, attending many of the interim meetings, being there and watching them work and being able to weigh into the process. And what we'd like to do today is help ensure that that task force continues.
Thank you. Any questions?
It looks like they've covered kind of a lot of the basis for the people that would be on this task force. Do you personally have any recommendations of anyone else that you think should be added to it?
Sure. Chairman and Senator Jones, great question. I think that the task force, as they have it laid out in the legislation, was very thoughtful by the sponsor and all those that were a part of it. I think in particularly, they're looking at housing next, and I do believe that there is a residential person on there and some other folks to look at it. So I think right now it's been thoughtful with the committee as proposed.
Thank you. Could you restate your last name for me? I didn't.
Defoe, yeah.
I'm sorry?
Defoe, Dafoe,
Okay.
yeah.
Very good. Thank you.
Great, thank you.
Any other questions for Mr. Foe? Well, committee, before we move along here just for a second, we want to think about what this bill's doing. And basically, all we're doing is continuing the regulatory reduction task force. And with that thought in mind, I didn't explain that very well before we started, but is there anybody else in the room that'd like to testify on this before we move forward? Seeing none, is there anybody online, Tanner? Okay, so we'll close public testimony. Committee, what's your pleasure on this bill?
Move the bill.
Moved by Senator Ellis. Any discussion or considerations? Senator Ellis?
Thank you, Mr. Chairman. I appreciate the WAM representative asking for us to change the composition. I would actually feel more comfortable if, he visited with the prime sponsors of the bill, and if they wanted to bring it as a committee of the whole amendment. This is their bill, and I just would defer to some of their feedback. So at this time, I would not offer that amendment.
Senator Jones, any opinions on that? I agree. Okay, I'm kind of in agreement with that. Let's kind of table that amendment for the moment. And with that said, any other discussion?
Question.
Tanner, you want to call the roll, please?
Senator Ellis.
Aye.
Senator Jones.
Aye.
Senator Rothfuss.
Excused?
Co-Chairman Dockstader.
Excused?
And Chairman Cooper.
Aye.
Mr. Chairman, there are 3 aye and 2 excused.
And here comes our hero, Senator Rothfuss, right on time. Tanner, if you leave that vote open for the gentleman, we would
We're on our
appreciate it.
third bill already.
Yeah.
Third bill, how'd mine go?
We haven't got to it.
You're gonna tell us how yours went in just a minute, Senator Rothfuss. Okay, committee with Senator Rothfuss in place, we're gonna consider Senate File 96, Trust and Bank Assets and Bankruptcy Clarification. Senator Rothfuss, you want to take this away?
Thank you, Mr. Chairman. And Mr. Chairman, we've got my co-chairman, Representative Western here in the room. Mr. Chairman, Senate File 96, Trusts and Bank Assets in Bankruptcy Clarification. This was the work of the Blockchain Select Committee during the interim. We didn't get it finished quite in time, so you'll see that rather than it being a blockchain bill, it's simply sponsored by all of the members of the Blockchain Select Committee. Mr. Chairman, This bill has a straightforward intent. It's a little bit on the long side to get all the language right and have conformance, but the idea is based on a discussion that we had in the select committee about assets that are held in custody by financial institutions and how those assets might be treated in the circumstance of a bankruptcy by that financial institution. For the financial institutions that are banks right now, federal law makes it pretty clear that that they can end up working to bankruptcy, although we'll hear from our commissioner that there's certainly a state role, and there's a lot of governance at the federal level for our state-regulated trusts. Then there's a lot more flexibility at the state level, and a lot of the requirements come down to our banking commissioner. But the key intent here is to make it very clear that any asset held in custody by that financial institution shall not, for bankruptcy purposes, be considered property of the financial institution, but rather is the property of the owner of that material. And this seems like it should be obvious, and that's true. It should be obvious, and yet it isn't, and it isn't always the case. And we wanted to be as explicit as we possibly could be, that to the greatest extent possible within the power of the state of Wyoming, we would clarify that those assets held in custody continue at all times to belong to the asset owner. And that should hopefully help keep those out of bankruptcy court, not just at the state level, where I don't think they would end up in bankruptcy court probably, but certainly trying to signal to the feds that the way we regulate is regulating to that separation, and hoping that they honor that. So, Mr. Chairman, as we walk through the bill, you see discussion of newly created receivership bankruptcy statutes, and I'll have Jeremiah, the banking commissioner, kind of come up and walk through the details of that. But this talks about covered accounts and how bankruptcy shall be governed. It gets specifically into digital assets, which is obviously under the purview of the Blockchain Select Committee. And the reason for that is that there are nuances to digital assets and how they are handled that is different from traditional fiat assets. And so there's clarification in here for financial institutions that receive digital assets, that on the requirements for them keeping those assets booked separately, even if they are included in common wallets or common digital profiles that might otherwise look as if they're commingled. So it basically sets standards for financial institutions to hold and custody these digital assets while still achieving all of the regulatory necessities to ensure that they will remain custodial instead of commingled with the assets of the institution that might threaten those assets in bankruptcy. Again, no other state has anything like this, and we work with some excellent attorneys from around the country and stakeholders from around the country to make sure that we're getting this right and leading in this space. Pages 4 and 5 and on to 6 also get to covered accounts and discussions of the financial institutions with regard to digital assets, providing for notice and ensuring that if you have achieved all of the requirements that we have through page 6, then you would be meeting with the regulatory structure that then allows for clarity that those assets are in custody and not otherwise the property of the financial institution. Page 7 gets to definitions, and these are all consistent with our financial institutions. Page 8, we start getting into discussions about stablecoin reserves. So we start talking about some of the definitions that are earlier in the legislation as we're looking at custodying digital assets and how that's managed. Page 9, a concept that we talked about a couple of years ago, the idea of staking, comes down to a digital asset practice that provides verification and validation of transactions on a blockchain, and that's something that these custodians can be doing with the digital asset while still not eliminating that separation of custody versus, conflated ownership. And from page 9 and beyond, we're looking largely at conforming amendments in existing statute, as well as the directive that you see on the bottom of page 9 and on to 10, which is important. This is a little bit of a separate nuanced point, but it's important, and it allows for a cleaner interaction between the state and the federal government during a bank insolvency. And you see if the commissioner has been appointed receiver under this section prior to the filing of a petition under Title 11 United States Code, the commissioner shall be discharged from further duties under the receivership after the resolution of any jurisdiction issues at the commencement of a bankruptcy proceeding. The idea there is a discussion that the commissioner can talk a little bit more about, where it's unclear in statute what happens when our banking commissioner begins in a receivership position for a bankruptcy of a financial institution. In this case, I think it's specific to banks. And then the federal government ends up taking over. It was unclear that his responsibilities effectively terminated at that point, and the transition goes to the federal government. So we wanted that clarity there so that it wouldn't weigh down that process any further. Page 10 is conforming amendments. And from digital asset custodial services, you see on page 11 that the requirements that a bank providing digital asset custodial services has to be compliant with the custodial service requirements pursuant to rules and regulations of the commissioner. That gets back to the earlier provisions about how those digital assets would be on the books so that they are appropriately represented in a way that does not demonstrate that they are the assets of the financial institution. And finally, the Q provision, a supervised trust company that is chartered in this state may provide all the services provided in this section if it complies with the provisions of this section and the rules and regulations of the commissioner. This is a clarification that a supervised trust company has these same capacities that our other financial institutions do. So that's kind of some cleanup language that we talked through that fits nicely in this bill. I think that hits all the key points. And Mr. Chairman, I'd answer any questions, but also we've got the banking commissioner, we've got my good co-chairman here that may want to provide some additional details that I may have missed.
Thank you, Senator.
And we also have, we don't have Senator Ellis anymore.
No, she-
Senator Ellis
she bailed
walked out.
on
I was
us,
going to
so.
say Senator Ellis is obviously also a member of the Blockchain Select Committee but is not here to answer questions.
Thank you, Senator Rothfuss. Before we move forward, Senator Kolb, I assume you're here for 131. We covered that already, moved it forward. There was one suggested amendment, and I'll talk to you about it. We'll discuss whether or not we want to bring it up on committee of the whole, as far as the amendment. So we did not make an amendment, but one was suggested, so. Not an issue. Yeah, it's no problem, Senator Kolb. Everybody's in the same situation this morning, so, thank you, sir. So, moving forward, Banking Commission, Commissioner, you want to talk to us about this a little bit?
Good morning, Jeremiah Bishop, Banking Commissioner and Administrator for the Division of Banking. Yeah, this is a bill that we have been working with during the interim period with the Blockchain Select Committee, and then also trying to draft some of the language. I appreciate them asking us and getting our opinion on this during the interim. It really helps out a lot. As Senator Rothfuss said, this is I think it is a very good bill. It's a very important bill to help provide clarity and even some protection to customers of either a bank or a trust company that's providing custodial and trust services. So a little bit of a background on this. So this is maybe a year and a half, 2 years ago. I think there was a major exchange of digital assets came out with a public notice saying that if you are their customer and they're custodying your digital assets, and if they were to enter bankruptcy, as a customer, you would be treated as an unsecured creditor. That your assets that they're custodying would actually belong to that exchange, not to you, and that you're an unsecured creditor. So that's treated, I'm not an expert in bankruptcy law, but I know that's treated very differently than in this case. So this bill, I think, helps fix that problem. Like Senator Rothfuss said, it does make sense, but it's not actually written down anywhere. And this provides very good clarity of how exactly these are treated in bankruptcy. So a little bit of background on what happens if financial institutions fail or go bankrupt. So banks, they are not subject to federal bankruptcy law. If it's a traditional bank that fails, the commissioner is the receiver. We generally pass that receivership duties off to the FDIC. They have a whole team that they're experts on how to wind down banks. So that's how a traditional bank is wound down in the event of a bankruptcy or a failure. An SPDI in Wyoming, that is specific to Wyoming. Now, most SPDIs, they're eligible for FDIC insurance. However, most of them are not going to get FDIC insurance just because of their structure. So since the FDIC is not a supervisor and they're not involved, the division then is the receiver for that company. So it's our job to disperse assets back to, either disperse assets to the customers, whether it's deposit liabilities or has assets held under custody, whether that be traditional assets or digital assets. So we could do that a number of ways. We could actually find the owners of those assets and disperse them, or we could find another institution to acquire the failed bank and take over the duties that that bank was conducting. Now, trust companies are similar. There is no federal regulator. However, trust companies are not banks, so they are not exempt from federal bankruptcy. So the language on page 9 changes to 13.5.417. That's existing language saying that, okay, if this trust company were to fail, again, the division would be the receiver. It is our job to find, if it's a traditional trust, successor trustees for all the trust accounts. Now, that's a very timely process and also a very expensive process. And then if they're also providing custodial services, those are a little bit easier to actually disperse because you don't need a court-ordered successor trustee in that case. You can just disperse those assets back to the customer. But what this section does is it gives me the option at any, the existing language is in lieu of taking receivership, I could send that failed company to federal bankruptcy court. However, I think my understanding of the existing language is I can really only do that at the beginning. It's in lieu of. So once I start that receivership process, I think it's unclear whether or not I could send it to bankruptcy court partway through that receivership process. My understanding is that the language that is added allows that flexibility. I could maybe, if it's a digital assets, for example, and they have strong, as what's required elsewhere in this bill, books and records on the owners of those assets, I could maybe return those assets to the customers, hopefully fairly quickly. And then if they're doing other traditional trusts or other activity that is going to be just costly to wind down, then I could send that section to bankruptcy court. That's my understanding of that section. The rest of this bill, a lot of it has to do with definitions and requirements as to a lot of agreements that are in place, whether or not it's a custodial account or a fiduciary account. There's some language in there on, again, stablecoin reserves and staking activity. I know it was actually very difficult, I think, to come up with an actual legal definition of staking. My understanding is that actually doesn't really exist anywhere in the country. It's a very common practice. And a lot of the trusts or banks or in this industry, they offer staking services. So I think that's actually a very important piece of this. And I think they did a really good job of creating that definition. So our job is at the division, if this were to go through, is if you're offering these services, whether it's custodial, fiduciary, staking or stablecoin reserves, is just ensure compliance with this section. A lot of this is those agreements between the customer and the financial institution, so we would review that during examinations. And then obviously, we'd also be looking at the books and records to make sure that at no time are those assets considered commingled with the assets of the company. That's something that's very common in the trust industry, traditional trust, that's already in law. That you cannot commingle assets of your customers with the company. However, it's unclear with digital assets, so that helps. So that's some of the things that we review during our examinations. And then on the last page, there are 2 pages. These are the changes to 3429-104. That's our custody law, digital asset custody law. I think it is Q, the fact that it explicitly says that this statute applies to supervised trust companies. With the passage, when the SPDIs came in, this was I think passed around the same time. It was really geared towards the SPDIs and banks. However, since then we've seen definitely an increase in supervised trust companies that offer digital asset custody services. So we've used that same statute in our corresponding rules as a kind of a guideline for just safe and sound practices. However, it's not explicitly said that they have to comply. That section Q now makes that explicit. If you're doing this activity, you must follow these same rules that the same activities govern whether or not it's at a bank. I think that's an important piece. You don't want to have different standards just because it's a different type of entity. Have the same standard for the same activity regardless of whether or not it's at a bank or a trust company. I think that's just a good practice. And it's one, like you said, we have been doing, but we don't have a lot of enforcement saying you have to. This makes us say, okay, you now have to comply with this. Hopefully there might be some other public comment on this, but if there's any questions I could answer, I'd stand for questions.
Thank you, Commissioner. Any questions from the committee? I think that'll handle it for now, Commissioner. If you hang around a little bit, we'll have any more, we'll get back to you. Is there anybody else in the room that would like to testify? Representative Western, do you want to throw your name in the hat here? No? Okay. Tanner, I believe we have one online, is that correct?
So, Mr. Chairman, before that starts, I do have a couple of other people online that were interested, but they couldn't sign up. I think, are there 2 separate signups? Is that how we're doing it? So each of these meetings has a separate sign-up queue, or they were struggling because it said the meeting starts at noon?
There was 2 meeting notices put out, one for the 8 a.m. and then one for the noon time as well. So there's 2 different registrations that they were able to do online. And then the registration closes at an hour before the meeting. So it would have shut off at 7 this morning before the meeting. So
They were noticed separately.
They were noticed separately. Okay, but maybe it's the fact that it was shut off at 7 o'clock today that was the problem. Okay. Is it possible to reopen that at this point? Is that to reactivate that link?
I believe we are able to send them an invite. We could do that really quick if we have an email that we can forward a panelist link to.
Okay, I will send that to you in moments. Thank you. And yeah, we've got 1, but there should be 2 more. Thank you.
Tanner, do we want to go ahead and bring Ms. Hagan on, please?
Hello? Are you able to hear me?
Yes, ma'am, we are. You want to state your name and have at us.
Great. Thank you very much, Mr. Chairman. My name is Carrie Agin. I am actually kind of speaking for a number of folks. The public who knows that Wyoming Stable Token is being built are extremely concerned about a number of things. So I'm going to kind of speak to this bill a little bit, speak to the current statutes, and speak to some concerns that we have. A lot of the concerns we have are with regard to these other institutions that may take custody of assets. And I apologize, we're still getting up to speed on the terminology, that kind of thing. So I'm trying to find here, okay, here we go. Covered account, custodial account, fiduciary account, and then sub-custodian. Sub-custodian especially is a big concern that some of these relationships may open the door for what would essentially be money laundering. Can you, Mr. Chairman, speak to that, or someone on or the commissioner, to how can I word this? How things are being monitored to try to avoid things like that? I mean, we're very concerned that Wyoming may get sideways with the Securities and Exchange Commission and take a pounding, including financially.
I'd be happy to, and the commissioner can join as well.
Thank you.
Yep, thank you. So all of the efforts that we're putting forward, we're being very careful to comply with the Bank Secrecy Act's KYC, AML, Know Your Customer, anti-money laundering laws, and have honestly put in a tremendous amount of work to ensure that we are consistent with all of those federal laws and regulations, which are targeted at exactly that. So whether it's the Wyoming Stable Token, which this legislation doesn't specifically address, or whether it's any of the digital asset work that we're putting into place, that is being thoughtfully negotiated, and the commissioner can talk more about this. It's actually one of the things that we're doing uniquely that other states aren't, and that's an important thing. We have a well-developed regulatory structure. We have supervision. We have policies that are cognizant of how digital assets differ from traditional fiat assets and how they can be used differently in money laundering. So I understand that there's always concern with new technologies, but there's sort of two ways to go about it. One of those is what most of the rest of the states are doing, which is just saying this isn't happening, we're not going to look at it, we're not going to do it, we're not going to regulate it, and then somehow hoping for the best. But the alternative is to do what we've been doing, which is to regulate to enable a technology and then provide substantial consumer protection to the greatest degree we can while enabling technology. So, and I'm very sensitive to the concerns that you raise, and that's precisely why we've spent so much time on getting the regulatory structure right so that we can be addressing those types of concerns. And Mr. Chairman, I think the commissioner has something to add.
Thank you, Senator Rosas. Chairman, you want to address this with us?
Yes, thank you, Mr. Chairman. Yes, so no, BSA, that's Bank Secrecy Act, that's a requirement that applies to all banks and trust companies. This is something that we review during every examination, whether or not it's an SPDI, a traditional bank, or a trust company. Just a little bit of background on what this is. The biggest thing, or one of the pieces, is know your customer laws. So before a financial institution can onboard a customer, they have to gain certain information on that customer to gain an understanding of who they are and then the source of funds to ensure that it's not supporting some illicit activity. It's a very important piece in stopping money laundering, is just know your customer. Traditional banks, it's your local community, so it's a little bit easier. SPDIs and trust companies, especially in the digital asset space, it's more global. So your customer may not be somebody that you've actually met personally, but you still have to comply with those laws. You still have to know who they are and where their funds are coming from. And then with digital assets, you still have to screen those assets. There are tools out there for blockchain analytic tools. We have that in our rules, that you are required to use this technology to help identify where that customer got those funds from. And with digital assets, you can trace those all the way back to when they were minted. And you may not be able to identify the actual person, but you can at least find the wallet addresses, things like that. And it helps you conduct research just to know the source of funds. I think one of the questions was, okay, the use of sub-custodians, and does that open the door for money laundering? So if you're a digital asset custodian, a lot of times you're not actually going to be controlling those keys yourself, or you don't have to. You might contract with a third-party sub-custodian service provider. That third party will be the one actually controlling those wallets and those keys. So when a customer deposits funds into maybe a wallet, it's actually done through this third party. Now, just because our trust company or bank or financial institution is using a third party, it does not mean that they don't have to comply with BSA requirements. The risk is still on the company. It's still their customer They still have to ensure they know who that customer is, even though it's now being routed through a third party. So the third party, there are requirements possibly on them as well, depending on who they are. A lot of times it's another trust company in a different jurisdiction. They also have to comply. But either way, our financial institution has to know all this information regardless of the sub-custodian. Now the comments on the SEC, I'm not an expert on this, but I do know that the SEC has been increasing enforcement actions in the digital asset space. I know there's really no clear law at the federal level in this space, and so they are regulating by enforcement action. I don't agree with that, but that's the tool they have, and that's what they're using at the moment, lacking federal guidance. Wyoming, I think we have a much better overall program in place, both the legal structure and regulatory structure to help guide some of this, so that I can't do that. So I can't say whether or not this would have implications with the SEC, mainly because I don't know what rules they're enforcing. There has been enforcement actions on staking, particularly on whether or not digital assets or staking products are considered securities. That's something that we make all of our entities do. If you're going to be offering this certain product, you must get our approval before you can offer it. Part of that approval is a legal analysis of whether or not it's a security or not.
Mr. Chairman, you don't see a clash out there with what's happening at that level, federal level and our level. We're just going to proceed to do business, put this together and do business, right?
Yeah, thank you, Mr. Chairman, Mr. Co-Chairman. I'm always open to working with the SEC. We have agreements in place with most federal regulators. If there is any overlap in place, if anything were to come up, if there was some enforcement action by the SEC with one of our entities, we'd actually work with that, whatever that federal agency is, to ensure, to see if it's a problem with our law as well. Should we join that enforcement action, or should we'd at least need to be aware of it to see if there's any follow-ups we need to do from a safety and soundness standpoint. Now, if one of these companies falls under the SEC, yeah, they're gonna have to comply with the SEC. That's part of doing business in this space. So I wouldn't say I would not clash with the SEC. I'd try to work with them as best as possible if that situation were to arise. Thank you.
Thank you, Commissioner. Ms. Egan, I hope that explanation helped you. Did you have another comment on the bill itself?
Thank you, Mr. Chairman. That was it at the moment, these general concerns, and I appreciate the gentlemen, all of them, providing that explanation. That was extremely helpful. Thank you very much.
Okay, thank you, Ms. Hagan. Senator, who else do we have online there, please?
Mr. Chairman, we do have Joe and Joel both online from Senator Rothfuss. So,
Okay, would you bring him on, please? Gentlemen, if one of you want to go ahead and jump in here, I'm not particular about which one speaks first.
Sure, I could start, Mr. Senator. Joseph Evans, I'm a partner at McDermott, Will, and Emery, and I run the crypto group here at McDermott. And just a few words on this proposed bill, and one more thing to add to Ms. Hagan's concern on money laundering and the use of sub-custodians. It's important to note that in order to be a sub-custodian for the purposes of this bill, you must be a regulated financial institution, licensed money transmitter, or a bank, and such. All of the Bank Secrecy Act requirements that are required for those entities would apply here too. So I think that should alleviate Ms. Hagan's concerns. With respect to this bill, I thought Commissioner Bishop did a great job of summing it up. We have represented almost every crypto bankrupt estate or creditors committee in that crypto bankruptcy estate, including Prime Trust most recently. One of the purposes of this bill is to ensure that customers who intend to have their assets bankruptcy protected are in fact bankruptcy protected. And so what we wanted to do was to include some clear language of what needs to be in an agreement in order to be protected in bankruptcy. The reason why it's important to do this on the state level is because in a federal bankruptcy court, they turn to state law to determine whether a trust agreement exists, such that it will not be treated as property of the estate and used to pay professionals and used to do whatever the estate decides to do. That was the aim and the purpose behind this bill. And with respect to the concern about conflicting with the SEC, this bill is intended to protect consumers in bankruptcy. That's the goal. This bill is not saying whether staking or staking as a service or any other type of activity is a security or a non-security. The focus of this bill is customer protection, and that those customers who opt to store their assets with the Wyoming Trust Company, a Wyoming Speedy, or other regulated institution in Wyoming that's covered by this bill are protected in the unfortunate event of an insolvency of such an institution. And so we're happy to answer any questions. Our team has worked a lot on this and made sure that this was clear. The point of this bill was clarity. And so that's why we put distinct language as to what needs to be in an agreement in order to be a covered agreement. And I think we've achieved that here. And so thank you all for your time today. Happy to answer any questions.
Thank you, sir. Is there any questions for the gentleman? Okay, if the other gentleman would like to go ahead and speak, please.
Thank you, Mr. Chairman. My name is Joel Revel. I am a Governor Gordon appointee to the Wyoming Blockchain Select Committee. And I am also founder and CEO of a Wyoming chartered public trust company. And I just wanted to speak to the benefit to consumers, but also to those of us in the private sector here in Wyoming. This bill adds much needed clarity to avoid consumer harm and also allows us to hold ourselves out as Wyoming chartered public trust companies as being domiciled in a state which provides that consumer protection and that legal clarity. So fully support this bill from the perspective of a Wyoming trust company. Thank you.
Thank you, Mr. Revel. And Tanner, do we have anybody else online? Is there anybody else in the room that'd like to speak? Come on forward. If you'd please introduce yourself and
Good morning, Chairman and the rest of the committee. My name is Lisa Jurdy Spillman. I'm a director of SAFE, which is a division of SFOX. We are also a regulated Wyoming trust company, and we are grateful for this bill. We like the separation that it has for custody, for customer assets versus the trust company assets. And we also appreciate the addition of supervised trust company to the definition of custodial services and who can provide custodial services. It clears up a gray area that was clear by the commissioner's testimony that supervised trust companies could provide it, but it wasn't in the statute. It was pursuant to the rules and policies of the Division of Banking. So we appreciate this opportunity. We appreciate that this is now clear in the bill that this applies to supervised trust companies.
thank you, ma'am. Any questions for the? No, I guess we're good. Anybody else in the room? With that, we'll close public testimony. Committee, what's your pleasure?
Move the bill.
Moved by Senator Dockstader. Senator Rosses.
Second.
Oh, you're second, I'm
Yeah,
sorry.
sorry.
Any discussion? No discussion. So since we're ready for a vote on this, Tanner, if you'd call the roll, please.
Senator Ellis.
Absent. Excused.
Senator Jones. Aye. Senator Rothfuss.
Aye.
Co-Chairman Dockstader.
Aye.
Chairman Cooper.
Aye. And we do have a, we do have, Tanner, we do have a proxy aye vote for Senator Ellis.
All right, thank you, Mr. Chairman. That would make it 5-aye. And motion to
Thank you,
pass.
Tanner. With that said, I think I'll turn this meeting back over to Senator Dockstader.
Thank you. Excellent work. You knocked out 3 bills one morning. We're going to catch up. We're going to get done. And we'll be back at noon and we'll finish all the joint minerals work and send our bills to the House and they'll send theirs to us. So thanks, everybody. And thanks to Vice Chair for running the meeting.
Were those votes, Lily? One sec, Lily, no. Were those votes held open? I don't know if you held the votes open
Yes,
for us.
I did.
Okay, so I'm an aye on both. Thank you.
And for the record, I'm an aye on both too. Thank you.
All right.
Thanks, everybody.